Hi, I'm Anna Denton-Jones, and in today's session, I want to talk about a recent case that's shed some light on a debate that a lot of employers are having about returning to the office and the extent to which employees need to be in and the reasons why perhaps that might be. The case involved a tribunal claim that took place in November in the Croydon Employment Tribunal, and it involved somebody in a fairly senior management position. It's worth setting out at the outset that this is not a health related disability reasonable adjustment type of case. So this is just somebody who had been working from home throughout the COVID years when people had to, and so felt the request after COVID to return to the office on just 2 days of the week, so only 40% of the time, was unreasonable, and that her employer should grant her the flexible working request to enable her to work fully remotely. An employer has 8 business reasons that it can say no to such a request. They have to sort of shoehorn their reasons into one of those 8, but 2 of those 8 involve things like impact on the quality of somebody's work, impact on performance. So when the person's request was turned down, she was told it was about not being able to attend face-to-face training or being able to deliver it, because in her position perhaps she might have had to do that, not being able to attend departmental away days if she was not in the office, not being able to coach new joiners, not being able to participate in team celebrations, not being able to engage in team meetings where information was being cascaded down, not being able to get involved in team planning. Now, there is part of my mind that says, well, can't some of those things be done via Zoom or Teams or something? When it came to the appeal stage, the appeal hearing person made a very good point that this isn't just about you and what you want, it's about how you, in your senior management team position, fit in the organisation, both with those that you directly manage but also indirectly manage, and some of it's about them and their ability to access you for face-to-face contact, and the idea being that team performance, team collaboration is better if people have got that access to face-to-face contact. The Employment Tribunal sided with the employer. That's probably not that surprising, because let's face it, if they sided with the employee, probably that would open up a huge can of worms. What the judge went on to say is perhaps worthy of note if you are ever having to make decisions in this space. It pointed out that many of us who are using technology, that the technology isn't always suited to the fast pace of exchanges which occur in meetings or training events when there's an interaction about something, and that there is a limited ability to observe and respond to non-verbal communication when using these electronic and digital systems, which are an important part of us all working together. Obviously, they took the seniority of the individual into account as well. So it's worth knowing, if you have got to deal with a request, that the law is on the employer's side, And of course, in this particular case, they were only asking the person to come in 2 days a week. It wasn't as if they were asking them to come in 5 days a week. I suspect they might have struggled if they were asking somebody to be in full time. It's about balance. It's about blending these things together. So I thought that might be interesting for people to hear about that. If you've got any questions, do give me a call, ADNTON @refreshinglawltd.co.uk. Thank you very much.